We're answering another question today on complete estate planning, and this is the question we have. What happens if one of the people I named it in my will as my beneficiary dies before I do? What happens to their shares? They go to someone else automatically. We'll talk through that, what it means for you, and how do you make that decision coming up next. Welcome in. This is Complete Estate Planning. Ben George with Nick Rosenbauer, the Rosenbauer Law Office there in Ohio. You can find everything online at CincinnatiEstatePlan.com. So, Nick, today's question dealing with beneficiaries, right? And this is probably something that you've seen before. Maybe I don't know if it's common, but if a beneficiary dies before you do, what happens to their share, those assets that you had earmarked for them?
Well, this one is all dependent on your will or your estate plan. So every estate plan, should have something in it, some sort of direction that says if this it can be done individually, where if this beneficiary passes away, here's where his money goes, but this beneficiary, her money goes here. Or I've even seen it, which is okay, something broader or more generic to say if any of these people pass away, maybe their money goes to their own kids or their money just goes back in the pot for the rest of the beneficiaries. You'll have to have, some sort of clause in there for a contingency, whether, the contingent beneficiaries, whether it goes on down the line. And I will tell you from personal experience, the majority of the time, if money's going to children or something like that, if they pass away, a lot of people choose to have, the person who passed away, their money go to their own family, like go down to their own kids. Mm-hmm. So like if I was supposed to get an inheritance, I passed away, in most instances, my money would go to my own kids and kind of stay in the family. But I would say second most common thing would be kind of just giving it to the rest of the beneficiaries. So if there were 5 beneficiaries, one of them passes away, then it just becomes 4 equal shares or 3 equal shares or 2 equal shares. And again, for our listener, that's a great question. It should be whatever is in your document. So the good thing about that is you get to pick. So it is not a default where you have no control over it. So, but I will say this should also raise a red flag if your lawyer didn't ask you. Okay, so if you say, "Hey, we never went over this," something's in there. It has to be in the document. Something there has to be something that it says. But if your attorney does not ask you that, then you need to be concerned. But the good thing about it is you can have it go exactly how you want, regardless of circumstances.
What happens if your attorney didn't put those contingencies in and you don't have a plan for that? What happens to that share for that beneficiary if they do pass? Does something automatically happen?
Yes. Now, that's a good question. It'll depend on the state law.
Okay.
And it'll depend on the type of instrument. So, we have, succession laws and testacy laws, and then our probate code, and our trust code, and every state has something that has, a lot of them are defaults. That can be overridden. And it will basically say if a document is silent or if a document does not say who the backup is, if something happens, then it will go here. So probate codes and trust codes, depending on your state, they're all state specific. But there are rules in there that basically say if the document is silent or if no arrangements were made, here's what will happen with money that's kind of stuck at the end of the line. Now, you're not picking. It's way better, obviously, Ben, if you pick what you want to have happen, which sounds like a given. But there's a backstop in almost all circumstances. I don't know if it's the one you want. And if it's me, I'd rather all of my clients tell me what they want instead of just guessing and hoping for the best. There is a backstop, but I don't like to rely on it. I like to ask my client, what would you want to have happen in this instance? It's always the best option.
And I guess if you do have a beneficiary die, is that a time that you want to go meet with your estate planning attorney and talk about things and just review your plan?
Yeah, that's a good question. This should prompt a call to your attorney's office to at least do a checkup or a review. because instead of saying, well, if something happens to one of them, a lot of times if they're younger than you, people don't take that question seriously. And no wonder. Ben, if you were in my office and we were talking about what happens if your brother, who's 15 years younger than you, dies before you'll
Right.
give me something, but you'll obviously say, well, odds of that happening are low. It's probably not a big deal. But it's good to review. So we can at least say, Ben, when we did this before, we said if your brother's not around, here's what happens with his money. Obviously, I'm sorry for your loss. Are you still thinking that's what you want to have happen with his money now that we know it's a certainty? Or do you have any other thoughts? I'm not saying that we always have to change it, but it's a good time to do a review.
Gotcha. Okay. Well, great question. Something to think through. Again, if you don't have a contingency in place, make sure you do have a plan for what happens if this does occur in your life. Again, if you haven't worked with someone, need some help with that, need to review your plan, CincinnatiEstatePlan.com. Nick in the Rosenbauer Law Office can help you with that. And again, we'd love to hear your questions, so keep them coming. And please subscribe to the YouTube channel if you haven't done so as well. Nick, appreciate the breakdown. Talk to you again soon.
Yeah, absolutely. We'll catch you next time.
Are you feeling overwhelmed by estate planning? The process can seem complex, but it doesn't have to be. The Rosenbauer Law Office is dedicated to helping you protect what matters most: your family, your assets, and your peace of mind. Nick and the team will guide you through every step of the process, making sure you feel confident and informed along the way. Take the first step toward peace of mind today. Schedule an introductory call by clicking the link in the description of today's show.
This show is for informational purposes only and does not provide any legal advice. Information on this show may not constitute the most up-to-date legal information. Please do not act or refrain from acting based solely on anything you hear on this show. This show does not form any attorney-client relationship with the Rosenbauer Law Office, LLC. Please seek the counsel of a qualified attorney before addressing your own estate planning needs.